second, y'all, and I'll be right back. All right. Let's see what we got. What we got. I'm a little thirsty. Okay. How is everybody doing? All right, y'all. Today I have a call-in number. I should have put the call-in number in the title, so let me go ahead. I'm gonna give y'all the call-in number right now. Give me 1 second. Sorry, y'all. I'm just getting everything started. I know I've been gone for a little while. I've actually been on um, Facebook doing lives on there. Let's see here. Okay, here's the call-in number. That's the call-in number right there. Let me see something. Okay. Y'all call in. The call-in number is 319-527-6727. Why is it showing up like that? I don't like the way that that's showing up. It's like the light is off or something like that. So let's try to go around here. Hopefully I'll make that'll make the quality of it better. Okay, y'all, we're gonna be talking about civil cases and criminal cases. So y'all call in and we'll just go from there. 319-526-6727. Hopefully y'all can hear me. Go ahead and hit that like button for me, y'all. If y'all don't mind, please hit that like button for me. Until I get somebody, that's gonna raise their hand, I'm gonna go ahead and just start talking. So, this is what this is what your legislatures are doing. I'm not sure if they're doing this in other states. I believe that they are, but I'm not sure. But what they are doing, I've already said this once. They are creating administrative agencies via statutes, and they're calling these agencies courts. Excuse me. They may call it something like the Circuit Court of something county or the Superior Court of something county, something like that. And what they're doing is they are investing quasi common law and quasi equity jurisdiction in these administrative agencies. They don't just do it for common law and equity; they do it for all of them. They're investing in these agencies. You might hear something like they call it an inferior court. An inferior court is something that was created by the legislature. So here's a case in Alabama. This is from 1922. I got to go and get this case. It's from 1922, and this is just a holding in the case. It says the legislature has the unquestioned power to vest in inferior courts of statutory creation any of the powers or any portions of the jurisdiction of the chancery or circuit courts to be exercised concurrently with those courts if the latter are not completely and constitutionally supplanted. They're doing it everywhere. They're doing it everywhere. We can get into, like, if y'all have questions about y'all civil cases or criminal cases, call in and we'll talk about it. If I can help you, I'll help you. If I can't, I'll let you know that I can't help you. I have done divorce cases, never done an expungement, but I'm 100% sure that I can do it. I've done criminal cases, I've done federal lawsuits, state lawsuits. All of this stuff is the same exact thing, y'all. Everything is the same. None of this stuff is different. The only thing what they're doing is they're um they're doing everything under statute. So what they have done is they have codified um, common law crimes. And what I mean by that is like resisting arrest. Well, I don't know if resisting arrest is in a, um, a common law crime, but let's just say like assault and battery or something like that. They're codifying common law crimes, and they're incorporating them into statutes and codes. The reason that they're doing this is because it's under another form of jurisdiction. It's under the admiralty jurisdiction. That's what they're doing. Another thing is Yusuf L. He is right when he says they're filing liens against you. That's exactly what they're doing. Because in a civil case, if you litigate a civil case against somebody and you win and you get a judgment against them, with that judgment, you can file a lien against their private property, all of their property. I'm not sure if you can throw them in jail, for it if they don't pay up or whatever. But you can file a lien against them, and seize their assets. You can do that. It makes so much sense to me, and it just so happens that the Georgia actually is just telling you that that's what they're doing. That's exactly what they're doing. They're filing a lawsuit against you in the nature of admiralty jurisdiction in the form of civil law, because all crimes are commercial. They construed everything to make it commercial so that they can exercise their authority over it. The call-in number 319-527-6727. Y'all call in. I hope y'all can hear me. Is anybody having any problems hearing me? Hope y'all can hear me. Let me see what's going on. Let's see. Okay. I hope y'all can hear me. If you can hear me, just let me know. Let me know if you can hear me. If you can't hear me, just press 1 or something like that. Go ahead and hit that like button. Please, if y'all don't mind, hit that like button. Another thing, as proof of my theory that they are creating administrative agencies and calling them courts, all U.S. district courts and all courts of appeals, all federal courts of appeals and all federal U.S. district courts, those are administrative agencies. They're just calling them courts. The reason why they're administrative agencies is because they're enforcing statutes. Okay, so if you litigate a case pursuant to 42 Section 1983, when you're suing for your rights being violated, that is proof that they have vested in that administrative, in that federal or U.S. district court, quasi-equity and quasi-common law jurisdiction. I'm going to tell you how. Because you can get an injunction and you can get a remedy at law in the same proceeding in a 42 Section 1983 lawsuit. So an injunction is an equitable remedy. There are no statutes in equity and there are no statutes in common law. So what they're doing is in that particular jurisdiction, which is admiralty, you're using a statute. That's how you know the jurisdiction is admiralty. Okay, but you're filing the claim in a territorial U.S. district court. I'm listening. I'm at work though. Thanks. I can hear you. Okay, appreciate it, Chris. Thank you. So this is what a remedy. I need to do a video on this. A remedy at law is money damages. There is no money. Everybody knows that everything is a negotiable instrument. There is no money. There's only the appearance of money. Okay, so but you can get money damages pursuant to 42 Section 1983 in a federal lawsuit. You can. I know you can because I've got one. They cut me a check at my settlement conference last year. They cut me a check. So I know you can. So it's really all smoke and mirrors, to be honest with you. All of this stuff is just smoke and mirrors. use of his right, they've tricked you out of our jurisdiction into their jurisdiction. That's exactly what happened. Um, what else I was gonna say? Let me see something. Oh, I gotta check the phone lines, y'all. Give me a second, because I had somebody called in the last time, and he needed some help with something. I forgot what he needed help with. I'm sorry. Um, let's see. Okay. I'll hold off on that. I'm just gonna start talking about criminal cases. So if you have a criminal case, it depends on what it is. Everything starts with the facts. Y'all already know that everything starts with the facts. It's always about the facts. Me personally, I never go to court without any paperwork filed, ever. I don't care if they don't have a court reporter in there. What I do is I make a record. And here, pursuant to a statute, you automatically get a trial de novo, meaning you get a whole new trial if you lose. You're going to lose in municipal court. You can just forget about that shit because it's not a court of record. They're going to do whatever the fuck they want in there. So the chances of you winning and losing in there are the chances of you winning in there are slim to none. I've won in there before, but it's difficult because there's no record. But you can get a trial de novo in the circuit court, and that's where you want to be. You want to be in a circuit court where there's even though it's not a court of record. Let me rephrase that. They call it a court of record, but it's not really a court of record because it's missing one element, one prerequisite element that is needed for it to be a bona fide court of record, and that is they have to be proceeding to the jurisdiction of common law, and they are not doing that because they're there enforcing statutes and following statutory procedures. That's what they're doing. Do any of y'all second guessing the nature of the action? Or any of y'all not sure or uncertain that you know for a fact that the nature of the action is admiralty? Because I'm 100% sure it's admiralty. It is admiralty. Just by the bonds that they're using. If you haven't read Clerk's Praxis, please go and read Clerk's Praxis. Clerk's Praxis is going to give you all of the admiralty bonds. They're going to be in Latin though, but they're going to give you all of these bonds. And what you should do the same thing I did. What I did was I found all of the statutory bonds in the so-called criminal cases for the state that I do a lot of litigation in, and almost all of those bonds, I know 3 of them are admiralty bonds. 3 of them. So ain't no confusion. The nature of the action is admiralty. They're filing lawsuits against you. That's what they're doing. Equity is where we need to be, ladies and gentlemen. Common law and equity. How you do I'm actually gonna do a video on it soon. But I promise you, all of this shit is so easy. If you can understand if you can draft a 42 Section 83, a 42 Section 1983 lawsuit, you can draft an action at law or a declaration at law. When they say declaration, declaration is it's synonymous with complaint, but that's just what they call a complaint when you're prosecuting a lawsuit under the jurisdiction of the common law. They call it a declaration. It's the initial pleading. That's what they call it. If you can draft that federal lawsuit, you can draft a common law action. You can draft a bill in equity. I promise you can. All of this shit is easy. All of it. There are no statutes in equity. Get that shit through. There are no statutes in common law. Okay? What you need to do is how you plead a bill in equity is basically you plead facts to show that you have an injury, and that equity is the appropriate jurisdiction to get your remedy. So when you plead your facts, you need to plead facts that show that that these facts are equitable in nature, and the remedy that you're seeking is equitable in nature, like an injunction. An injunction is an equitable remedy. When you're doing common law, all you do is plead facts. It's always about the facts. Facts. If you plead an assault and battery, you're not going to do it under any statute. You're going to cite it. You're going to, as your authority for invoking the court's jurisdiction, what you're going to cite is the Constitution, because that is the people's document. The people's created a court in the Constitution. And the court that the people's created, that is the court that the people litigate in. I didn't know you were here. I got something new today. You can call in today. I have a call-in number. The call-in number is 319-527-6727. You can call in and we can talk about it. I'll be here for about 2 hours. I'll be here for about 2 hours. Did y'all watch that video that I put? I think I did it yesterday. Attorney versus counsel. Did any of y'all watch that video that I uploaded yesterday, or did any of you go and read the case that I was reading yesterday from that video? Hit that like button for me, y'all, if y'all don't mind. Hit the like button for me. Let's go here. How many of y'all what are y'all having? Man, I'm choking on something, y'all. I'm sorry. Are y'all having trouble with understanding anything as far as the jurisdictions? There's 4 jurisdictions: common law, equity, maritime, and admiralty. Are y'all having any problems with understanding those? All of it works the same way. Everything's based on the facts. Everything is based on the facts. Everything. In common law, not common law. What is it? In admiralty, they don't call it a complaint. In admiralty, they call it a libel. Libel. But it's still a complaint. They're just using a different word for it. They call it a libel. And whoever files the libel is called a libelant, or in other words, the complaint. What happened? Initial status conference, civil. Call into the show, Tina. Call in 319-527-6727. I know you. Oh, I know YouTube only limits. You can only type 200 letters, and you can't really say much. So just call into the show. Y'all call in, ask your questions. I'll be here for 2 hours. Hit that like button for me too. Hit that like button, y'all. Hit the like button. If you're in Alabama and you want to know where their bonds are going to be with risk management, probate court, or the Secretary of State. If you're looking for the bonds for all of the judges and prosecutors in Alabama, you need to contact risk management. They are covered under the state's blanket bond. So when you contact risk management, you're going to talk to, if he's still there, his name is Daryl Masters. That's his name. He is the one who's going to send you what you're asking for. What he's going to do is he's going to send you back an insurance policy for the corporate state of Alabama. So what I'm trying to tell y'all is the judges, except the probate judges, the circuit judges, the district court judges, the prosecutors, and the municipal judges, they don't have their own separate bond. They're covered under the state's blanket bond. That's what you want to get. You need to contact risk management and they'll give it to you. Once you get it, they're probably going to be insured by somebody who is from another state or something like that. I think they renew it every year, every 2 years or something like that. They renew their insurance policy. But that's what you want to get. That's who you need to contact to get a copy of that policy. The probate judges, I found the probate judges' bonds here on a local website. Have a status conference coming up. Any information you can provide? Status conference. I don't think I've ever attended a status conference before. The only conference that I attended was a settlement conference. So let me see. I'm gonna Google it and see what's going on. and see if I can give you some insight just from that definitions. Give me 1 second. Let's go here. Let's see. So it says, I'm gonna see if it can provide me with some more in depth um, details, because this is, I mean, it's not bad, but it's not good either. All right. All right, Tina. It says a status conference is a meeting that occurs before trial where attorneys from opposing parties and sometimes a judge meet. The nature of a status conference often depend on the type of case. A status conference in a criminal case, well, this is a civil case, but anyway, a status conference in a criminal case will often consist of prosecution and defense attorneys exchanging evidence, but they sometimes may involve discussing plea bargains. In civil cases, status conferences can involve exchanging evidence, stipulating to certain terms, and starting negotiations on a settlement agreement. We didn't do any of that. We just had a settlement conference. So this kind of makes sense. Okay. So I guess it's like an update of the entire case at one setting, or so to speak. So let's say if there wasn't a settlement negotiation prior to the status conference, and you go to the status conference and you like, you know what, we're just gonna settle this case. So at the status conference, the court will be notified that okay, we're gonna settle this case. Are we going into settlement negotiations, or the judge might, I mean, not the judge, but the parties might say, Your Honor, we're gonna take about 2 weeks to see if we can settle this case. Can you give us about 2 weeks? Can we get can we motion for a continuance or something like that? We get a continuance and give us 2 weeks to see if we can settle this case, and if we can't, then we'll just go ahead and go to trial or something like that. That's what it seems like to me. Um, okay, it says sometimes a judge will attend a status conference to give their opinion on plea or settlement offers and setting timelines for the pretrial matters. Okay. So it seems like Tina, excuse me, y'all. I don't know why I'm losing my voice. Um, okay, Tina, have you so you, based on this, you must have already been going through discovery. I'm gonna assume that you've already been going through discovery since they want to hold a status conference. Would that be correct, Tina? Somebody, let's see, who's this? What is this? Some message. I don't know. Some message. I was trying to read your message, but it must be deleted. Um, Let me see if I got anybody raising their hand right now. All right, everybody's just listening. If you have questions, look, this happens every time I come on and I get out there. Every time I come on, I just have people listening. Most of the time, they just listen. They don't raise their hand. They just listen. And then when I get off, I get emails. Come on, y'all. I'm here for another hour and 30 minutes. Press one, and I'll answer your question if I can. Or I'll give you some type of advice. The call-in number is 319-527-6727. Okay, she says I can't call in right now. That's cool, Tina. That's cool. But were you at you've already been through discovery, right, Tina? Would that be correct? You're welcome. You're welcome, Tina. It must be some type of, I don't know what's the delay on it. It must be a delay. Anyway, what was that? Where was I? Um, okay. Right now, I'm gonna give y'all the analogy. So, if you want to understand what's basically, if you want to understand how the process works, you're better off in a civil case than a criminal case. So, in a civil case, this is how it works. Remember when I told y'all the plaintiff always picks the jurisdiction because the plaintiff is the complaint and he is the one invoking the court's jurisdiction. So the plaintiff always picks the jurisdiction. And when I say jurisdiction, I mean the nature of the action. So let's just say if I file a complaint, I plead nothing but, and I only plead facts that show on its face that this is that this is in a suit that is exclusively belonging to the jurisdiction of equity, because I pled facts to show that this is an equity dispute, and and the remedy that I requested is an equitable remedy. So as soon as a judge looks at that, they're going to say, okay, well, this is an equity this is an equity jurisdiction case or something like that. That's basically how you do it. If you're in if you want to file an action at law, you would file a declaration, you would plead your facts, and then you would ask for money damages because a remedy at law is money damages. Somebody must be out there shooting or something. Anyway, when you're in the plaintiff, when you're prosecuting a case and you're the plaintiff, you are a prosecutor. That's why they'll dismiss your case for want of prosecution if you don't prosecute the case. So you are a prosecutor. You pick the evidence that you want to use against the defendant. You decide what evidence that you need to request from the defendant. You talk to whoever their attorney is. You're going to talk to him throughout the whole entire trial. You're not going to talk to his clients at all. You're going to talk to him. You're going to have his email, his address, and his phone number. You're going to talk to him throughout the whole entire trial process. Not yet. I just got a notice conference. This is a civil case. You need to call in, Tina. If you can, call in. How much time do you need before you call in? Because I need to talk to you over the phone. They already had all the information. When you get some time, Tina, call in. Back to what I was saying. The plaintiff always picks the nature of the action because it is the plaintiff who has the injury. The plaintiff always picks the nature of the action. Always. That how you determine the nature of the action is you have to look to the remedy that the plaintiff is seeking. That's how you determine the nature of the action. That's another way you can determine the nature of the action. What else? In a civil case, you're prosecuting the whole case. You are a prosecutor. You decide what type of causes of actions that you want to sue the defendant for. It's just like a prosecutor. That's because you are a prosecutor. The prosecutor does the same shit on the criminal side. They do the same exact shit. They decide which evidence that they're going to use, what evidence that they're not going to use, what witnesses who they're going to subpoena to court and testify, what type of charges, the types of bond. The same shit. It's the same exact shit. The prosecutor, whoever the like the police officer, when they saying you did what is it? They like to say disorderly conduct or failed to obey or resisting arrest, but they never allege the facts in support of how they came to the conclusion that you committed these so-called crimes. They're not crimes, but they never have the facts to support it. So that is no different than you saying a police officer has assaulted and battered you and has unlawfully arrested you without facts showing how you came to that conclusion. Is any of this making sense to y'all? It's the same shit, y'all. The same shit. Both sides. You have to give them the facts in which you're basing your cause of action on. They have to give you the facts in which they are basing the so-called charges on. If they don't, they violate due process. That's why If you file a lawsuit against a police officer and you don't allege facts in support of how you came to the conclusion that, let's say, a police officer unlawfully arrested you, they're going to file a Rule 12b6 motion to dismiss because you failed to state a valid cause of action. That's what they're going to do. Probate judges are different from other judges. Probate judges deal with deceased persons or incompetent persons, stuff like that. I'm not really sure what are you getting at though, Miss G. I'm gonna call you Miss G. I'm not really sure what your question is. That's why I have a call-in number. Call in and press 1, and then we can talk. Okay, need a minute. I will soon. I can break away. Okay, Tina, that's cool. That's cool. All this stuff works the same exact way, y'all. It's all the same shit. It's all the same shit. All the same shit. All the same shit. It's all the same thing. In a in a civil case, you cannot testify if you're not a witness who has firsthand knowledge and you are competent to testify. In a criminal case, you cannot testify unless you have firsthand knowledge and you're competent to testify. Same shit, y'all. It's the same shit. Don't matter what, it don't matter. It's the same exact thing. So always remember, if you're in a civil case, you're a prosecutor. You can, if you're in a civil case, you cannot present any type of evidence to use against whoever it is you're suing unless you give their attorney a copy of that evidence. Unless their attorney sees that evidence. See, they have to see it. You have to serve them a copy of it. It's the same thing in a criminal case. Same thing. Same exact thing. Let's see, what else? What else? Y'all need to study equity and common law. That's it. I mean, you can study admiralty too, just so you can know the nature of the action, but you need to study equity and common law. Equity is where real men and women litigate their disputes. That's where you go. You go to a court of equity, or you go to a court of law. They call it a court of law. But now, since they've merged all the courts together, they just call it a court of general jurisdiction. General jurisdiction just means that they hear cases at law, which is common law, cases of, like in a court of chancery, cases in equity, in admiralty and maritime. It's the same shit. They just playing these word games with people and trying to confuse motherfuckers. That's what they're doing, and they throwing you off. These people are not smarter than you. All you have to do is just go and read. That's all you have to do. And if you really want to know what they did, you need to go and read old cases, so you can get a history lesson. You have to go and read these old cases sometimes. Diversity of suitors. I need to read that some more, Josh, because I have heard what you're talking about. I have heard what you're talking about, but you have chancery do it. I got treaties. Okay, that's good. You got treaties on it. That's good. Everybody, well, I don't know, because they didn't, from what I've read, the research that I've read, with the exception of probably about maybe 6 states, all the other states have merged all the courts together, with the exception of about 6. Some of them, they're still separate. So I would, I need to, I wish I was in one of those states to where the jurisdiction was still separate, because I can go and get a rule book for equity, and it would tell you the rules of procedure when you're prosecuting a case in equity. I really wish I can do that. I think the closest, enter into admiralty to assimilate the maritime contract and stand over them in one court of justice till you try. Chancery is the circuit court in Michigan. Okay. So is that do they Michigan? Let me see. So they haven't merged. So you're saying that they haven't merged the courts in Michigan, Josh? Is that what you're saying? They still separate? Just to let y'all do know that there are no statutes of limitations in actions at law or equity. I don't well, there's an equitable affirmative defense, what they call it lashes or something like that. That's an equitable affirmative defense. But it's not a statute of limitation, but it can be used to dismiss your suit in equity. Uh, yeah, but they still do this or that. Circuit court is the entry into real cases. Okay, so they did merge the courts. But yeah, you're right. You're right. The circuit court. I would say you're right. Unless, man, look, these legislatures, they tricky as fuck, man. They real tricky. They are called an administrative agency, a circuit court. And you think your ass is in a circuit court, and they'll give this circuit court um um uh jurisdiction that mimics the actual circuit court. And now you're confused. But then if you do your research, then you'll know which is the real court. Lashes, threats, duress, and coercion, age of minority. What else I was gonna say? Damn, I was gonna say something. I forgot what I was gonna say. Y'all need to call in. I mean, press one. Y'all just be holding the phone. Just counterclaim the lashes. Okay. Um, there's no statutes of limitations in a court of law. So you should be, I'm not sure what an affirmative defense would be for a claim of assault and battery in an action at law. But this is what I'm going to do. I have a lawsuit that I want to draft against a police officer. He did something to me about 3 years ago. And he probably forgot. I didn't forget. So I'm just trying something out. So what I'm going to do is I'm going to draft an action at law. And I'm going to give them substance. I'm going to pay the filing fee in gold or silver. And I'm going to see what I get. That's what I'm going to do. And he ain't getting out of that complaint. Because I know exactly what to say and what not to say. His ass is not getting out of that. And they don't have any cameras, and I'm the only witness. And he's a witness, but whatever. I know what I'm doing. He's the one who's going to need an attorney, not me. Working and listening. What's good, Jerome? What's good? Do you have any case law info on how the law interprets the word agreement when not technically referring to a contract? Not right now, I don't. SG, what you can do, you can go to a local law library, and you can get it. They should, when you go to corpus juris secundum, they pretty much have hold on, SG, I'm gonna get into that. They should have they go into all topics within a certain subject. Let me see. And they should answer your question in there. Shit, I forgot what I was gonna say. I'm sorry, y'all. Y'all forgive me, y'all. I'm sorry. You say how will he pay? Well, look, me personally, I don't want a negotiable instrument. So if I pay in gold or silver, what he's going to need to do is he's going to need to get his insurance company, because his ass gonna have insurance. He's been indemnified. I'm 100% sure of that. He's going to need to get his insurance company to cut him a negotiable instrument, and he's going to have to go and cash that negotiable instrument, and he need to take his ass to one of these local gold and silver pawn shops or whatever around here, and he needs to get me. I'm gonna ask for about $25, maybe $30,000 or something like that. Maybe 50. I probably ask for more than that. He needs to get me 50,000, 30, 40, whatever, that amount of dollars in gold and silver. And then he can come to me and he can satisfy he can satisfy that judgment. If he don't do that, then I'm gonna file a lien against his ass. That's what I'm gonna do once I get a judgment. That's what I'm gonna do. File a lien against his ass. If y'all just tuning in now, Yusuf L be knowing what the fuck he be talking about. I don't agree with everything Yusuf says, but he do his research and he know what the fuck he talking about. And this is what they doing. When they get a judgment against your ass in a criminal case, a so-called criminal case, they filing a lien against your ass. That's what they doing. And that's why they seize your ass. That's why they seize your body. These folks slick. They so damn slick. For real, SG, that's what he gonna have to do. Me personally, I don't want a negotiable instrument. I don't. Oh, I want gold and silver. That's what I want. They already trying to get rid of the shit anyway. And if you know what money is, then you're not really worried about it. Because I know what money is. Money is whatever the fuck I say it is. Money is whatever the fuck me and whoever I'm doing business with say it is. That's what money is. Oh, you're welcome, man. She no problem. That's where you need to go though. You need to go into I mean, I can do some research. It'll probably take me some time to find it. Is what I'm getting at. That's why I didn't do it while I'm going live. But I can do some research on it. Matter of fact, let me see. I'm gonna see if I can do a cursory analysis of it for you right now. Give me a second, SG. Let's see. Okay, I found something on it right now. I'm gonna read it, and then we'll see. This is why I don't like dealing with these people. You have to listen, man. When you're dealing with these people, you have to go and do so much fucking research to find out the definition for one fucking word. I've read cases, y'all, where they're arguing over the meaning of one fucking word. One word. One fucking word. They arguing over this shit. It's a whole case on this shit. Anyway, if y'all haven't watched the video when Attorney versus Counsel, please go and watch that video. If not, at least go and read the case that I'm reading in that video. That'll help y'all better understand it. That dude, I ain't gonna even lie, y'all. I thought they was gonna rule him off as a sovereign citizen. You know how they do when you come in there and you know you right. You feel me? But they don't want to respect you. They don't want to give you no credence that you know what the fuck you talking about. They just some disrespectful. What's one of their terms? They're not honorable, dishonorable motherfuckers. That's what they is. That's what they do. I actually thought that that's what they was gonna do, but whoever that judge was, he didn't do it. He went into the history of that shit, and it makes so much sense when he break it down. SG, let me read this to you. Let's see. Okay, a contract is an agreement, but an agreement is not always a contract. See, this is what the fuck I'm talking about right here, SG. This is what I'm talking about right here. An agreement can be informal or may be in writing. A contract may be verbal or written, but a contract will always be enforceable if it contains certain requirements. Modern contract management. Oh, let me see. Let's go down here. This is what is an agreement? An agreement is a manifestation of mutual assent by two or more persons to one another. An agreement may be as simple as two neighbors arranging lawn care equipment, or as complicated as terms and conditions. See what the fuck I'm talking about? You see what I'm talking about, man? These folks, they be playing all these damn games, man. They get on my damn nerves. Hold on, y'all. Like you just can't never get a straight answer out of these damn people. Let's see. to use the terms hold on, let me see. Okay. An agreement is a meeting of the two minds to a common intention, made with an offer and an acceptance. To use the terms and conditions example, the app is offering to allow the user to access their services under certain conditions. Okay. And the user accepts by clicking the accept button, which lets the app download or whatever. Okay, that's an agreement. Let's see what they're going to talk about a contract. I'm going to say, what is a contract? So it seems like a contract has more ingredients. Let me rephrase that. It seems like a contract has more qualifications or prerequisites than an agreement. SG, that's what it seems like. But hold on, give me a second. A contract is an agreement. See this shit? Look at this shit. Look at this shit. Just already throwing a motherfucker off. Anyway, man. A contract is an agreement between private parties creating mutual obligations enforceable by law. There are specific elements required to create an enforceable contract. So here are the elements right here. Mutual assent or a meeting of the minds, okay? Offer and acceptance, consideration, capacity to contract, legality to contract. The requirements of mutual consent and offer and acceptance are similar to that of an agreement. Consideration means that the exchange is made for adequate compensation. Give me a second. Let's go here. A good example is an employment contract. The worker agrees to work a specified job in exchange for a stated rate of payment. Let me see. This shit is too long, but I think it's pretty good information. But I'm gonna send you this, SG. I think it's pretty good information, and if I find any more information while doing legal research one day, I'll post it to the community section, and hopefully you should be able to see it there. I'm gonna send you the link to this right now, SG, and you can read it. Let's see. Might be too much. There's the link right there, SG. Okay. How to appeal a superior court conviction to an Article 3 court. JL, that's a good question. The problem with that is you're already in another jurisdiction. And I think, in my opinion, I hate to discourage people, but I think, in my opinion, it would be difficult to get an Article 3 judge to accept this case based on an argument that you're in the wrong venue, or that you were convicted under a jurisdiction that you shouldn't have been convicted under, because it's just so controversial. They're not, if they accept that case, in my opinion, they would have to admit that you were convicted in the jurisdiction of admiralty based on your argument, if that's what you're going to argue, because you're trying to get from one jurisdiction to the next. Would that be correct, JL? Is that what you're trying to do? Let's see. I don't want them getting me on conduct. Okay, SG. Okay, I got you. Garcia, both agreement and contract require full disclosure. I agree with that, Jerome. Add entry on stipulation for cost, U.S. Code 281916. You got an email you can view and speak about. You got an email. What do you mean, Tina? Do I have an email I can view and speak about? Are you trying to email me something and you want me to read it and go over it on the air? Is that it? SG, there is a stipulation that I waived a certain right under the terms of the court order that I didn't knowingly waive. The terms don't even exist in the order. There was no meeting of the minds. Okay, I see what you're saying now, SG. I see what you're saying now. You're welcome. Let's see. I tried to reach the Chancery 1 week ago. See if I'm still. Well, Chancery shouldn't be hard, Josh. It shouldn't be hard. They don't. When we talking about admiralty jurisdiction, they don't want to talk about that shit at all. They will never tell you the nature of the action. It's admiralty, but they'll never tell you that. They gonna deny that. They'll say statutory jurisdiction, or they may lie to you and tell you it's common law jurisdiction, but they ain't finna tell your ass it's admiralty jurisdiction. I know it's admiralty jurisdiction. Let's see. Appeal bond. If you read the res judicata, it is overturned in the constitutional courts. Appeals, state supreme. The lower courts don't use it. The working acts. I'm a little confused about what you're trying to say, Josh. If you haven't already, y'all hit that like button for me. I really appreciate it. Let me put this number back in here again and let y'all know that I have a call-in number. And y'all can call in and we can talk. I did a consultation for a guy sometime 2-3 weeks ago. Oh, okay. Okay, Josh, I'm sorry. I didn't know. I did a consultation for a guy about 2 or 3 weeks ago, maybe. And he was telling me that his attorney told him that a lot of the arguments that the so-called sovereign citizens use are correct. But he was saying he can't go in court and argue that because he would get in trouble with the Bar Association. I believe that. I really believe that. All right. Sorry about that, y'all. We got disconnected. Sorry about that. Somebody called my phone and I can't answer it right now. Yeah, Tina. Give me a second, Tina. That's the email address right there, Tina. Let me know when you email it, and then we'll go ahead and do it. Yeah, y'all know. Somebody was telling me that you can bond a case. You don't even need the GSA bonds or anything like that. And I'm convinced that you can. I've never done it before, but I'm convinced that you can. And the only thing that you would need to do is, probably title it bond, and then your bond needs to have all of the prerequisite elements that are needed to make it a bond. It's just a promise. Like, I promise to appear, or I promise that if I don't show up, you get this, and this, or something like that. I really believe that that'll work. I really believe that it's just that simple. A lot of this stuff, to be honest with y'all, is very simple, but we just don't know how simple it is because we thinking that it has to be perfect, and it doesn't have to be perfect. You can write a writ of habeas corpus on a damn napkin in jail and file that shit in court, and you can get a hearing on it if you know what you're doing. If you know how to plead your case, you damn sure can. Okay. So, do any of y'all know how to draft a bill in equity or a declaration? A declaration is another word for a complaint exclusively in the jurisdiction of the common law. The initial pleading in an action at law is called a declaration. At law means common law. Does anybody know how to draft one of those or a bill in equity? If you don't, it's very easy. I'm gonna start doing some, probably not this. It'll be later on this year because I'm still studying it, but I'm about 100% sure that I know how to do both of them. I'm gonna let y'all know how that action at law go too, because I am gonna sue that police officer for assault and battery in the circuit court under the jurisdiction of the Constitution, and I'm gonna file and I'm gonna pay that filing fee in gold or silver, and I'm gonna see what the fuck happened. I'm gonna see what happened. I'm gonna demand a common law jury under the state constitution, all that shit. I'm going straight to circuit court. Let me see. I'm gonna check my email right now, Tina, and see if I got anything. I got a phone call. I have to call them back. Y'all hit that like button for me, please. If you're new and you're just tuning in, hit that like button for me. I really appreciate it. I'm gonna post that case again for y'all, that case citation, so y'all can go and read that shit, so y'all can know the distinction between an attorney and counsel. I'm convinced after reading that case, because they always read when they spoke on the term counsel, they were doing it. They were saying that this was the term used at common law, under the jurisdiction of common law. They were called counsel. So I'm convinced that you have a right to the assistance of counsel to all actions, whether it be civil or criminal, under common law jurisdiction. That's what I got from the case. Even though they didn't say that, that's what I got from the case. And it seems like you don't have the assistance, you don't have the right to the assistance of counsel under the other jurisdiction, which is admiralty. You don't have that. You don't have that right. You can get an attorney, a member of the bar, and his first duty is to the court. That's not it. I'm checking my email right now, Tina. Just checking to see if you sent anything. Unregistered foreign agents. I believe that too. I honestly believe that you can use the 11th Amendment and claim foreign sovereign immunity against these people in a court case. I really believe that. But I would have to study it some more, but I really believe that you can, because they are not sovereign. Pope says sue him. And that was my attorney that said a lot of the sovereign citizen is true. Oh, so that was you, JL. Okay. Cool. People just don't know how to plead their case, and they can't entertain it. That's true too. JL, I have the treaty is basically a treatise, but it's Alabama law, but it's discussing equity. So you says I need a bill of equity to enforce an estoppel by acquiescence on an administrative process. Do you know how to plead your case, JL? You had a post somewhere, maybe in the community tab, offering to share a document that was hundreds of pages long. SG, was it relating to was it Fourth Amendment jurisprudence? Was it about the Fourth Amendment? The clerks won't accept gold or silver as payment for filing fees. I've tried, paid via U.S. postal money of the census backed by gold, allegedly. We're gonna try that here. We're gonna try that shit here. See, they don't know me, because I'll file a writ of mandamus against these motherfuckers to the circuit court, and I'll take that motherfucker all the way up to the Alabama Supreme Court, because you're denying me access to the public record. Excuse me, you're denying me access to my remedy. In the state constitution in Alabama, it says wherever there's a right, there should be a remedy. That's guaranteed in the state constitution. So in Alabama, you can damn near sue for anything. Can't remember, I'm looking, okay. Let me check my email again. I'm gonna log in. I'm gonna see if I can read you something, Jay. I'm gonna log into my account. Let's see. So an estoppel. I think this should be relevant to yours too, SG. Tina, let me see. Say you sent it. Okay, let me check, Tina. Let me make sure I sent you the right address, Tina. I might have gave you the wrong damn email address. I didn't get anything yet, Tina. But it's basically smartlowtv@gmail.com. That's my email address. I'm gonna go back and check. Yeah, I gave you the right email address. Okay. I'm gonna go to the table of contents, and he's trying to do an estoppel, which is an equitable remedy. Injunctive, equitable defenses, equitable estoppel. Okay. You probably already know what an estoppel is. I'm gonna read it to you. But what it's going to do, it should give you the elements that you need, so you can learn how to plead in action. I mean, not a suit in equity. Let me see. They combined law and equity in the courts in 1949 when they changed the rules via the Federal Rules of Civil Procedure. Yeah, they did. The courts no longer have concurrent jurisdictions, cannot decide both state and federal questions. No, going through. Says it ain't going through. Okay. Well, they merged the courts here. In I think 1973 or 1976. They did it in almost all of the courts, but I don't know the years that they did it, because each so-called state is sovereign or whatever. So it's different for different jurisdictions. Okay. Let me see. That wasn't SG. Was it SG? Say he was trying to do an estoppel. No, it was JL. Okay. I'm gonna read you some, JL. The doctrine of equitable estoppel is designed to prevent a party from asserting a right under a general rule of law when the party's own conduct renders the assertion of such right contrary to equity and good conscience. However, the party asserting equitable estoppel must be free from fault. The doctrine of equitable estoppel is separate and distinct from the doctrine of, so there's another one, they call it pari delicto or something like that. I'm not sure what that is, but anyway, to establish the essential elements, listen here, JL, these are the essential elements. To establish the essential elements of equitable estoppel, a party must show that, one, the party against whom equitable, let me rephrase that, the person against whom estoppel is asserted, who usually must have knowledge of the facts, communicates something in a misleading way, either by words, conduct, or silence, with the intention that the communication will be acted on. That's one element. Two, the person seeking to assert estoppel, who lacks knowledge of the facts, relies upon the communication. And the person relying on the communication would be harmed materially if the actor is later permitted to assert a claim inconsistent with his or her earlier conduct. It says the conduct, language, or silence on which equitable estoppel is predicated must amount to the misrepresentation or concealment of a material fact or facts. Let me go back in and check. So I got all these messages. I'm sorry about this, y'all. It went through. Okay, let me go and check, Tina. Let me refresh and see. don't see nothing, Tina. I don't know why, but I don't see nothing. I just refreshed my email and I don't see nothing. Let me see how much more time I got on the air. I got 54 minutes. So if you're listening to the show and you have a question, call in 319-527-6727 and we can talk. I don't see anything, Tina. I'm gonna give you my email address again because I don't see nothing. Maybe I spelled something wrong or something. I don't know. Never judge again. I've heard something similar to that. I'm still trying to find the distinction between the District Court of the United States and United States District Court. I'm trying to find a distinction, but like, what's the significance of them? I'm trying to find a distinction between the two. Jay, I'm seeing the biggest difference in complaint and bill of equity is addressing the judge as chancellor or in their chancery capacity. Is there more to it than this? Well, yeah. But can you call into the show, JL, and we can talk. Call into the show. Cause I mean, you typing too much. I know you don't feel like typing all that shit. You typing too much. And we can go ahead and have a discussion on it. Call in and press 1 now. We can go ahead and talk. I'm gonna go back and check the email again, Tina. I don't see it. I don't see nothing in there. I'm gonna see if it's in my spam. Okay. Who is Okay, I got it now, Tina. I got it now. Just let you know, Tina, I got it. Okay. You can speak around it regarding probable cause and 19 no showing of probable cause to delivery of marijuana to my resident. Okay. Let's see. Ain't even no signature on this damn thing. What is this? Nothing in there. Let me see if they got something else in here. Search and seizure warrant. Okay. It's a little vague. Okay, there we go. You are commanded to execute a warrant on blah, 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 blah. This is just, let me see something. An application by a federal law enforcement officer or an attorney for the federal government requests the search of the following person or property located, blah, blah, blah. Priority mail express, blah, blah, blah. I find the affidavit or record testimony established probable cause to search in front of personal property. Describe the search in here, blah, blah, blah. What is this? This ain't, I don't know who did it. What is this? I mean, I can't really read it a little. I can't really read it, Tina. I find that the affidavit or any recorded testimony established probable cause to search and seize the person or property described above, and that such search will reveal. Okay, where the facts at? In support of this, ain't no facts in this shit. I don't see none. That is this. I don't care if 1,000 judges' signature. That shit is legally insufficient as a matter of law. Ain't no facts in here at all. I don't see shit. Like because good cause has been established, unless delayed notice is authorized. Ain't no facts in here to support this shit. What you need to do, Tina, you need to get a copy of the affidavit. Get a copy of the affidavit, Tina. That's what you need. Get a copy of the affidavit. Because they can't have a search and seizure warrant without an affidavit. Get a copy of the affidavit and see if it's in there. Admiralty is concurrent. Okay, I got somebody. Oh, that's Jay. Okay. What's going on, JL? How you doing, man? Hello?
Hey, brother, can you hear me?
Yeah, I can hear you. What's good, man? How you doing?
Right on. Yeah, I was asking about that validity and that element other than addressing the chancellor.
Okay. So you want to know about the elements for a bill in equity, in an action for, in a suit for estoppel? Is that it?
Right.
All right. I read it once, but I'll read it for you again, just so you can understand it. And now what you need to understand is all of the elements may not be the same in your state. Not all of them. Like your state may require less than the state that where I am now. But I'm gonna still read it to you because they should be still, the principle is still the same. So let's go right here. Okay, the doctrine of equitable estoppel is designed to prevent a party from asserting a right under a general rule of law when the party's own conduct renders the assertion of such right contrary to equity and good conscience. However, the party asserting equitable estoppel must be free from fault. The doctrine of equitable estoppel, well, I'm not going to read that because that's not relevant. I'm going to read you everything that's relevant. Okay. To establish the essential elements of equitable estoppel, a party must show that, one, the person against whom estoppel is asserted, who usually must have knowledge of the facts, communicates something in a misleading way. So they have to misrepresent something to you, either by words, conduct, or silence, with the intention that the communication will be acted on. Two, that was one of the elements that I read the first time. Two, this is the second element. The person seeking to assert estoppel who lacks knowledge of the facts relies upon the communication. And three, the person relying on the communication would be harmed materially if the actor is later permitted to assert a claim inconsistent with his or her earlier conduct. The conduct, language, or silence on which equitable estoppel is predicated must amount to the misrepresentation or concealment of a material fact or facts. The misrepresentation cannot be as to the law, as the doctrine is not a bar. Let me rephrase that. Well, let me reread that. The misrepresentation cannot be as to the law, as the doctrine is not a bar of the correction of a mistake of law. Okay, I get that. We'll see if I can find you a case. Let me make sure I'm answering other people's questions too, by the way. Let me see. True Josh. Okay, they talking about something. Okay, so I don't have any more questions right now. Back to you, JL. Does that make sense to you? I think it would be better if you had a case on it. So you could just read that case over and over and over and over and over until you just get that shit seeped into your mind, to where you won't have to read the case no more. You'll just know it when whenever it happens, you'll just know it.
Yeah, the doctrine of estoppel is more so bringing that suit in that court of equity.
Okay, so you mean like how to plead the case? Is that it?
Right, pleading in the bill in equity versus a complaint.
Okay, it's the same thing. A bill in equity is a complaint. It's the same shit. They just call it a bill in equity. It's just like in common law, they don't call it a complaint. They call it a declaration. But it's the same damn thing. They're just using different words. They're trying to confuse you and trick you and shit. You see what I'm saying? That's what they're trying to do. But it's the same thing, and it's based on the same principles, meaning you have to have facts. These facts need to be sufficient in equity to show that you are entitled to the equitable remedy that you're seeking. Does that make sense?
Yeah.
It's the same shit. And if you're doing a common law lawsuit, you need to plead facts to show that you are entitled to a remedy at law. That's it. That's all you're doing, bro. That's it. They not smarter than you, my nigga. Don't fall for that shit. They not smarter than you, fam. They not smarter than you. They just read, bro. That's it. All right, so so let me see. I'm gonna go over this one more time. I'm not gonna read it, but I'm gonna ask you some questions that are relevant to it. So you want to plead an estoppel. So let me ask you this. Did anybody misrepresent anything to you? And did you rely on that misrepresentation? Of the one who you're seeking the estoppel against?
Relied on their silence or their acquiescence to terms of correspondence.
Okay. All right, so that's one element. Okay, let's go to the second element. The person seeking to assert estoppel who lacks knowledge of the facts relies, okay, you relied upon that communication. Okay, now let's go to the third element. The person relying on the communication would be harmed materially if the actor is later permitted. Okay, so would you be harmed materially if the one who you're seeking the estoppel against is permitted to assert a claim inconsistent with his or her earlier conduct? Would you be materially harmed if that happened? Do you see how this shit work? Once you figure out what the elements are, then you apply the elements to your set of facts, and you base your set of facts on these elements in determining if you have a valid equitable suit, so to speak, something like that.
But when you say that the complaint and the bill in equity are pretty similar, obviously it comes down to the substance of your pleadings.
Yes.
Are the judges to construe which has to put on, or is
yes, the judge is. Yes, the judge is. The judge is, if you plead your case right, when the judge looks at your complaint, and this motherfucker don't see no statutes, but he sees facts, and these facts are on their face, showing that you're pleading a suit in equity and you're seeking a remedy exclusively relating to the jurisdiction of equity, and he is no longer an administrator, and he is no longer a so-called judge. He is a chancellor. You see what I'm saying?
So the relief being sought, what would, are we saying like declarations?
No,
Versus like
the relief that you're seeking is an estoppel.
like a declaration, obviously asserting the estoppel.
Okay. Well, no, I think in equity they call it a decree. I think they call it a decree.
Right. Yeah, you're right.
So yeah, you see how they be playing these word games though. But a decree is just a judgment. It's the same shit. They just using different words.
Right.
And they banking on you not to know this shit. That's what they don't want you to know it. But I promise you, it's not hard. It's not hard. There are no statutes in equity. Ain't no statutes in equity unless the legislature has created an administrative agency and they have called that agency a court and they have vested quasi-equity jurisdiction in that administrative agency. So your the proper venue, you would with a proper court to adjudicate your bill in equity would probably be some type of court of general jurisdiction, or if the court is, if they still separated, then it would be a court of chancery or a court of equity. It's the same thing. It's the same thing. Okay.
Well, I got my bill drafted. We're looking to bring to here in the next couple of days, so I'll keep you posted. I appreciate it.
No problem, man. Good luck, man. Peace. Okay, let's see. Never judge again. Schaffen versus Hoffman for no concurrent jurisdiction in courts of law and equity. Do you never judge again? Do you have the actual case citation, like the numbers? Because I would like to read it. And how old is that? How old is that case too, by the way? Let me see. Classified by terms, bill of peace is an okay. Don't they misrepresent everything they claim anyway? Yeah, they do. They do, Omar. Okay. Never judge again. Can you place that citation in there for me, please, if you don't mind? Thank you. Handbook of Common Law Pleadings by Crawford and Ripley, 762 pages. Everyone should study this book. You have a copy of that book? Because I would like a copy of that, motherfucker. Please. I'm pretty sure I know how to do it, but I would like a copy of it. Just to let y'all know, I don't care if you're pleading in admiralty, if you're pleading in equity, maritime, or common law. Everything starts with the facts of the case. It's all based on the facts of the case. Are your facts sufficient to justify the remedy that you're seeking? That's it. These people are not smarter than y'all, man. They're not smarter than y'all. Need your email address. All right, I'm going to post you the email address again. Tina, I didn't see any probable cause in there. I didn't see. That ain't no damn warrant. What makes it a warrant is if it has all of the elements that is necessary. That's what makes it a warrant. If you go in the kitchen and you make let's say you make a vanilla cake or whatever, and you put now your vanilla cake is supposed to be a chocolate cake, but you actually use the light flour, whatever you use, and it comes out, it's a white cake or it's a yellow cake, but you put chocolate over it, and you call it a chocolate cake. Is that a chocolate cake? Is that 100% a chocolate? Hell no, it's not a chocolate cake. No, it's missing some ingredients. Just like that so-called search warrant you showed me, it's missing some ingredients. It's missing facts to show how they came to that conclusion on that there was probable cause to issue that so-called search. That ain't no damn search warrant. If that what you showed me was their justification for coming into your house or whatever they did, that shit is legally insufficient as a matter of law. That shit is unlawful, period. Okay, let's see. You rely on the government coming in their de-jure capacity to your determinant. For equitable estoppel, you must make them plead what capacity they are coming in when coming against you. I mean, that's probably true. Never again. I'm not really sure because I'm kind of a little lost at what you're talking about. I'm not saying what you're talking about is not true, but I'm a little lost about it. But these motherfuckers are not honorable. If they were honorable, when you go in and ask for the nature of the action, they would tell you, oh, it's admiralty. Yeah, it's admiralty. And we got you in here under some type of international contract. They would just straight up tell you, but they're not honorable. They're not going to tell you that shit. Sending you the law on it. All right, thank you. Appreciate it. They're not honorable. I don't consider them honorable. If you haven't already, please go ahead and hit that like button for me, y'all. Hit that like button. Pound it, pound it, pound it. If I was you, Tina, I wouldn't even mention the search warrant. I wouldn't even talk about that shit. I wouldn't even say they had a search warrant when they came out there because that is not a search warrant. That ain't no search warrant. And when they bring that shit up, You just say it's irrelevant. Motion to strike. This shit is irrelevant. This ain't no search warrant. This shit is legally insufficient as a matter of law. Because they gonna bring it up because they gonna use that to try to argue and say that they are entitled to qualified immunity. I'm getting hungry. Ain't no damn either. Okay, SG, if you watching this video, SG, what the fuck type of email address is this, man? This is hilarious. This shit is hilarious, man. All right, I'm reading your email right now, SG. Email post, but I didn't see a comment from me in the post. Okay, yeah, I got it, SG. I'll send it to you. As soon as I finish this live, I'll send it to you. Okay, it's cool. I'll send it to you again. It's matter of fact, I'll make a video while I talk about it right now. If you have any questions, go ahead and just press 1 and I'll turn your microphone on. Let me get back to this live. SG, well not SG. I have a it's basically like a memorandum of law or treaties of Fourth Amendment jurisprudence, and it is for all states that are subject to the jurisdiction of the Ninth Circuit. So that would be California, probably New Mexico, and I think Nevada. I'm not really sure, but me personally, I think everybody needs that. I don't care which so-called state that you're in, I would ask for a copy of it. If you want a copy of it, I'll send it to you, but I think everybody needs that. It was drafted by an attorney, and the shit is like 600, 700 pages maybe. It is really good. It's just, it is straight to the point. Straight to the point. Nothing but case law. I was in a hurry for something at the time. That's what I came to mind. Well, that still was funny though. I thought that was spam, SG. I didn't know that was a real email address. I'll send it to you as soon as I can, man. Let me check my phone lines. All right, good evening, caller 3626. How you doing?
Thank you. How are you?
I'm good. What can I do for you, ma'am?
I'm just listening to you.
Oh, okay. Did you have any questions?
Came up. I have so many. I'm forgetting.
Well, just take your time. Just start with one question at a time.
I was the one asking you about this probate judge. Remember the probate judge? I was just wondering when you brought that up because in the beginning of my thing, I always asked about probate. Nobody really gave me an answer about probate, but I've been talking to you about it. Anyway, but how do a person that didn't have anything to do with that probate end up in probate court?
That's a good question.
You know my.
Go ahead.
I said you know my case, but that's a different. But I'm just asking about that because I never even really thought about asking about that, even though I've shown you.
I would have to see what did they do to get you to to come in there. They had to do something. They had to file some type of action against you, some type of suit or whatever, to get you in there, or to at least make it appear that the court has jurisdiction over you. They had to do something.
Oh, when I went to probate court with my family, this is the same case of my family from years and years ago. That I think this is the person that took over the house. that went into probate court. And I don't understand. Is it probate court? Because we've been discussing a long time ago, and I never thought about that. The probate part. But that used to be my only question because it had nothing to do with probate.
What's the name? What's the name of the court that you're in now? That this case is in? I think you said. Let me. Well, I don't know what I.
District court.
You said district court.
District. You know I'm in the district court.
Yeah,
I'm
I know you in a state. Well, I mean, you're really in a territory.
Yeah, I'm in a, they call a city, they call it 10 square miles. I'm in all of it. I'm just right in the middle of, right here. I can look at the cops, I can look at everything. We right in.
Okay, so what is the name of the court that the lawsuit is filed in? And I'm gonna see. Is it well, everything is there probably federal then if that's the case.
That's what people keep saying, but I don't know.
Let me see.
They come federal. DC has federal. We still have districts. We still have district government stuff here. Everything didn't go federal, but most of it is federal. It is stuff. You know, everything right out of here. So I don't think you figure out the case I'm thinking about because there's so much stuff people be asking, but I'm on the same thing. I was just telling you something else came up today. So I'm just trying to figure out why all these different.
You said why what?
I'm telling you somebody I'm talking to. Huh? Excuse me. Huh? I'm calling back in 5 minutes. No, I'm calling back in 5 minutes.
Yeah, SG. She said District of Columbia.
Supreme Court.
You say what?
What's the name of your court you need?
It's okay. It's okay. I think we spoke yesterday. I think or day before yesterday, and I think you should do what I told you to do yesterday. Speaking of that, we were supposed to be looking up you some an attorney. Since you don't know what you don't know what you're doing, and you're just overwhelmed.
You don't know what you're doing. I know some stuff, but I can't get anybody on board. So I'm dealing with a whole lot of different entities, different people, even my own. And this is the problem. So just like today, I was telling my daughter, and then she says, okay, I did call the attorney. She hasn't called me back yet. I already called the one I already had. And I was looking at L stuff today, and I don't think he did the day I did it or something like that, but he don't answer. But I was listening to you, I know, I said you were supposed to help me look up some more people in the area.
Yeah, so but I need to know like exactly where you are and I know what type of case it is, but I need to know like exactly where you're at. So I mean I don't need your address or nothing like that, but I need to know where you are so I can look up some attorneys in that area.
Yeah. I'm in DC. It's the court, the Superior Court of District of Columbia Probate Division.
Okay, Superior
But
Court.
these people didn't have anything to do with the case that sent me something today. They keep calling me administrator.
They keep calling you a what?
Okay. I know. I mean,
Usually
I
involved.
was saying, okay, I was just, he was just telling me something.
Okay, we can,
About
me and you can say it again, ma'am.
he was just telling me something about the paperwork, the other party.
Okay, well, we can, if this is a very this is a very personal matter for you, so we can, we don't have to discuss this over the air if you don't want to. Um, but I mean, were you asking me what is probate court? Is that what you were asking?
I was just wondering how he got it, but because I was just listening when you brought up probate today, that was the first time I heard somebody bring up probate.
Well, it's probate court is where it's where lawsuits are filed on wills and estates, stuff like that. So
that's what happened.
Huh?
That's what happened with me. I went through the whole process. That's when I said I never going into this system again. But when they went after the house, when the case ended, I had sold the house. I sold the house. Well, that's what they went after. So the judge told me to go after that, but I tried to get him not to go. But it's still going on to this day. This is really, it's just a ongoing process. But they're really, really trying to take it without, they never answered.
Yeah, I know they should have answered, but I would motion for motion to dismiss based on them not answering that, because they cannot prove, they can't even contest the validity of your will. They can't disprove it. They can't disprove the validity of the will because nobody was there except for you, your I think your daughter or your sister or something like that. The only people who can come in and contest the validity of the will is people who are actually witnesses. Or what they could do is they could there's one way that they actually could I can't even get the damn words out, I'm sorry. But there's one way that they could actually contest the validity of the will, and that is they would have to look at the will and see if it has all of the necessary elements that it needs to be a valid will or invalid will. I mean, a valid will. If it is missing some elements that it needs to be valid, then they can contest the validity of it. But they haven't even done that because it's a valid will. And that's why they don't want to talk about it.
I have to go back to the will because it's so old. It went into, that's the first thing that they looked at was the will. And the first thing the judge said when he looked at it is her house anyway.
Yeah, exactly. So the case should have been over with right then and there.
It was. Because we know how they work.
Yeah,
all the guys, father said, oh no, my mama did this, we did this, and this, and it's a mortgage on the house, and she can't pay the seven. They just went through that, and he just looked and said, well, Mr. Perry, you gotta do this and that. Then he looked at it. I was like, really? And I knew this stuff happened.
Yeah, but what he's saying, what he was telling you was, basically he construed that as if they were contesting the validity of the will, so you were going to have a trial on it.
They were contesting. They said it was forged, it was this, it was that.
Yeah, but they got to prove that. You can't.
Some mistake that they did, so they left that alone. They threw that out. Or they tried something else. So the girls went along and, well, we can get an attorney, but my daughter went up there and said, my mother is doing what she needs to do to get an attorney. I never said I wanted to get an attorney, but that's what we got. They said, oh no, we're going to get an attorney from, but we did. She signed one in, then they got one, and that's when the fight started. And that's been, 12 years ago, 11 years. So now that I sold the house, you saw the paperwork, and now it's like they stopped got him to come.
Well, what you can do, let me see. You can, I mean, you can file a writ of mandamus, and you can file a motion to vacate. It's a bunch of stuff you can file because it's a valid will. It's valid. That's why they don't want to talk about it. That's exactly what they did. They gonna always do that. Anytime that's what attorneys do. when you write about something in the argument and it has merit and it's gonna go in your favor and you're about to get a ruling that you want, they're not gonna argue that shit. They gonna, pardon my language, they're gonna ignore it and come up with something that is completely irrelevant to it to try to throw you off your game and get you off point. That's what they're gonna do. They're gonna always do that.
So they want the other person to go into the appeal court. They don't even know if they want to do it, but the appeal court, and they want them to do it. But in that, they sent me on the paperwork, but he said you don't have nothing to do with that appellate court. Well, why do you keep putting me on stuff and sending me stuff? I never went under that judge. I never went there. She just assumed, she made all these assumptions about me. And I that's when we wrote the thing, but nobody's paying that no mind. So the attorney, I called him again to ask him, because I asked him before, why haven't we, when do we put something else in? He said, well, it'll be, I said, how long will it be for their answer? Because they only have 15 days. Like they're giving us 30 days, him on the appellate court thing, to file whatever.
You said they had 15 days to what? To answer that motion to reconsider that you filed?
Exactly, that one.
Okay, and you should, so when they didn't answer, you should have followed up with a motion to dismiss because they have a duty to answer that. So what you're saying is you filed the motion to reconsider and the judge issued an order on when they were supposed to respond to that motion to reconsider?
I don't know. That was the attorney got told.
That's normally what happens. So anytime you file a motion before court, let's say you file a motion to dismiss or something like that. Once you file a motion to dismiss or any type of motion, well, I ain't gonna say any type of motion, but just any type of dispositive motion, like a motion to dismiss or a motion for summary judgment. If you file any one of those, then the court will issue an order, and the order will be it's going to give the opposing party whom the judgment is sought against, meaning the motion, whoever you're filing the motion against, the judge is going to give an order with a deadline, giving them time to respond to your motion. And if they don't respond, then your motion gonna be granted because they're just gonna accept everything as true. That's generally how it's supposed to work.
Well, everybody told me to wait, so I waited, but then I felt crazy because I was like, something is wrong. It looked like we should be filing something against them. But nobody answered.
Yeah, you're supposed to file something against them now, but you were supposed to wait, but you were supposed to wait, according to you, 15 days. After you waited the 15 days, then you come back in, you file your motion to dismiss based on them not answering your motion to reconsider or something like that.
Yeah. Well, they always wait months before they even do anything, but I knew also, I thought they're going to come after your stuff, that appeal stuff, before they answer this stuff, because I don't know, the house is not in the, so how are they doing it? They putting everything back. I tried to explain it to you. I don't think I'm explaining it, but how did they put, when they went after the closed estate, how did they put it, what did they do? Like,
you say when they went after what?
But closed estate.
A closed estate. What do you say? What do you mean closed? So did you probate the will?
Yeah, the probate. After all the sale, everything went down and finished. It was closed. Now I had another attorney tell me that. He said that's closed, that's done. But he said that, but when they went in there, they still went in there and took it. She done took everything. She said she took everything, but I don't know. They found stuff, but I don't know what they really doing. But I think when they go all the time, months and months, without saying something, and come back with all that, I showed it to you.
Okay, you ma'am, Miss G, I'm gonna call you Miss G. You just need to go and get you an attorney who you trust. Remember what I told you yesterday? You need to get you an attorney who you trust. But you need to get you one that's a beast, that ain't gonna play with these people. That's what you need.
That's the best thing advice. Where do you find it? Somebody needs to tell me that. Because the best one I have is I've been with me from the beginning.
Okay, let me. That's who you need to hire then. If you say that's the best one, based on that motion that I read, that motion to reconsider was pretty good. So just stick with him.
Yeah,
he already knows the case, huh?
Yeah, but okay, that's why I said I was gonna ask him. Well, since they didn't answer that, what now? But then he's looking at the other stuff. I don't know what he said about the other stuff, but I don't. He back and forth, you know. The guy didn't want to bother with him, but he had no choice because the one he had paid all the money to, he had to fire him in the court, which I thought was a good idea, but he didn't know what to do after that. They gave him no more options, so they just devoured him in there. That's all I'm gonna say about that part.
Well, you need to go back and get him. Go back and get that attorney who drafted that motion to reconsider, and you need to hire him since he already knows the facts of the case. That's who you need. That's what you need to do.
I don't think he wanted to be hired. The reason I started that is because he was a probate attorney, and I seen the judge come for him a couple times in the court. Well, he was much younger than he is now, but anyway, you know, he don't. I think don't want him to know that because he's familiar with the case. He knows all about it. So because he's familiar with it, I think he wanna put his name or anything on anything. He'll do the work. He's tired for the work. But like I said, he don't want to be. Like my daughter was saying, when you didn't hire, I said, you know he don't want to be hired. How many times he said, I'm not sure. I'm not. He said that because he knows that if his name come up on there, they can go back and say, oh, okay, that was his attorney from the beginning. But if he can't, I don't think he can write this stuff that he wrote. He's going by what I'm telling him, or my daughter's telling him. He's not going by his law, his law degree. He's not going by that. He's going by what we tell him, as long as he doesn't put him past the attorney. So I mean, I thought, I'm going to go talk to him again and see what he want to write up again and what he want to do again. But I just getting kind of eerie because of the political stuff. Because I said, why don't they take me off this stuff while they kicked him? I have nothing to do with that. And that's what I started saying. You don't have nothing. I mean, the other person keeps saying, you don't have nothing to do with that. So I'm like, well, why do they keep sending me stuff with my name on stuff?
Here's I'm looking at a law firm right now in the District of Columbia somewhere. They call Prince Benowitz accident injury lawyers. They do this is a decent law firm. It looks like they do a lot of cases from what I'm seeing. I don't see I can't really see any reviews. Let me see. No, I don't see any reviews. But you can call in and say you can get a free consultation. So they do free consultations. So I can give you their number if you want it. I'll give you their number. And I'll look up one or two more for you. Let me see. I got about 9 more minutes on the air before I have to go.
I was there from 9 minutes. Now you say you got 9 more minutes?
Yeah, you let me see. Let me give you this number. Do you have something to write with?
Yeah.
Okay, it's 202 914 5471. Okay, let me go and look up some more of them. That's what you gotta do because you just write. Say it again, ma'am.
What's this law firm name?
Price Benowitz LLP. price, like the price of something in the store, PRISCE.
Mm-hmm.
I spelled that. I spelled that so wrong. Anyway, Benowitz, BEN.
Yeah, okay.
Yeah, BENOWIT. T as in Tom, Z as in zebra, and then it's LLP. So we're gonna look up some more. Top 10 probate attorneys in Washington D.C. Let's see what we got here. 20 years experience, estate planning, general litigation, divorce and family. Let's see. Speedwell Law, Wills Trust and Probate, certified professionals. He's got, looks like he got 38 votes. Fair, flat fee for high quality estate planning services. Let me see if I can read some of his reviews. So he opens 9 a.m. to 5 p.m. Let's see if I can get some of his reviews for you. 38 reviews. Review highlight. I got a referral from Misha Gear from my financial planner, and man, I'm so happy that I took up this referral. Very pleased with the service that Donna Murphy provided. Let me see. Is that it? Where is it at? Okay, here, yeah, the reviews down here. Very pleased with the service that Donna Murphy provided with our trust and estate planning process. We never felt rushed. Donna explained everything. Very thorough, excellent process from start to finish. Highly recommend. I found Speedwell through Yelp. Great people, fast, gracious, efficient. Price of a trust, and will was very reasonable. My wife and I, Michael, created our will and trust. It was a smooth process. He was very knowledgeable, and we're glad we did it, and we recommend him. These are a lot of people, by the way, 38 people. I'm gonna see if I can give you his number, and you can call him tomorrow.
You know, most of these people, and I already had one of our best attorneys, is a friend of my friend, a friend of a friend. And I went to him, he's the first one told me my will was good, but we didn't hire him. And he sent me to this, he told me, that's the one told me that that's over, done with, but he gave me to another one, his attorney. He read the stuff like you did, but he didn't want to have nothing to do with it. First thing he said, why didn't you want to hold? But isn't that a volunteer thing if they don't call you in it and you don't ask?
Well, no. If they have it is voluntary, but there's an exception to it. If they have a bona fide case against you, then you need to go up in there and handle that, or you will get a judgment by default against you.
They did that before, the judgment by default.
All right,
maybe that's what they call it.
Here's the
judgment by default. Maybe that's why they're not answering my stuff. But I don't know. They did that before, and that's when we got this guy, the same guy.
Here's the.
He put some paperwork in. I thought I was done with it because it was about the house and stuff, and I had already got rid of the house. So maybe that's what it's holding this stuff. I don't know. Maybe they think they got enough before. They defaulted me before and before. But what people, what they act like we don't pay attention to is how come you keep going after the same mistake, the same person over and over? Now y'all trying to do it again. With your other still money's out there. They say I owe you. So now y'all saying I owe you again. We're gonna sell the house, we're gonna take all the money, you don't get no money,
Okay, hold on, man. We getting off a little topic. We're getting off point a little bit. So let's focus, because we're not gonna get anywhere when we just talking about the problem. We have to actually do something about it. So this guy, he practices in Virginia, the District of Columbia, and I think Maryland, the one who I was just reading you the reviews about. His number is 703 553 2577. Okay, I'm gonna give you. I'm gonna
This is looking low.
He's, he's out of Virginia.
I have a do.
But he
DMV?
yeah, well, I'm not sure where, but he's out of Virginia, so he must be somewhere close by the District of Columbia if he's practicing in Virginia and the District of Columbia.
Yeah, the DMV. That's the person who calling me. He's in Virginia. The person that they gave my estate to.
Oh, okay.
He's out of Virginia. But
Okay.
some of this is familiar.
Here's another. Let me read some. Let me read some of his reviews. Right. This will be the last one because I probably have about 2 minutes left on the air. Yeah, I'm getting close.
Okay.
So let me read you this. Let me read some of his reviews. He does wills, trust, and probate, business law. Let's see. Let me get his reviews. After calling 5 different lawyers, James was the only one that took the time and with so much compassion from what I was dealing with to clearly answer my questions and got me to a starting point to deal with my brother's will. I would not hesitate to recommend him to anyone who is looking for honest, clear, and concise answers. Okay. The consultation I had was incredible. All of my questions were answered, and I was provided with information that I didn't even know that I needed. He was vital. He was a vital link in directing me to the perfect attorney who practices in my state. He is a very helpful and professional man. Okay, so he practices in Maryland, but Maryland is in the District of Columbia is in Maryland. It's the same damn place. So let me give you that number. The number that he has, it looks like it's 202-351-6825.
Okay. Name is James something?
Yeah, let me go back. Jade. I'm guessing his name is Jade. Matter of fact, let me see. Where is the area practice areas? Let me see.
90 seconds.
Yeah. Got a minute and 30 seconds left on the air. Yeah, Jade Law. His name is Jade. It's spelled Jayde. So I'm guessing his name is Jade. JD.
Okay.
Yeah. So I would give all of those people a call, explain to them your situation, and just go from there.
60 seconds.
You need to hire you somebody as soon as possible, because you're wasting time.
Okay, well, so you're saying the guy that already has.
Yeah, I would call all 3 of those attorneys tomorrow who I just told you, who numbers I just gave you, and also see if the other attorney who drafted the paperwork, see if he'll take your case too. Contact all of those people and see if you can find one of them to take your case. But I have to go. I have about 30 seconds online on the air, so the call is about to hang up.
All right.
All right. Good luck.
All right. I'll see. Talk to you soon.
All right. Bye-bye. Okay, let me go back to the chat. Sorry, y'all. I've been away from the chat. I'm sorry. Issue. Okay, I'm so hungry, y'all. Every time I get on here, I'm always eating and I'm hungry. Okay, that's the end of the show. Before I end this live on YouTube, y'all, do anybody have any questions? Any questions before I go? Any questions? I'm so hungry. Any questions, y'all? I'm gonna end the live. If I don't have any questions in about 1 to 2 minutes, I'm just go ahead and end the live. And that'll be it for today. I'm tired anyway. Any questions? All right. Well, I'm going to assume that nobody has any more questions, and I'm gonna go ahead and end the live for tonight. I'll try to do 1 or 2 more. Thank you, Never Judged again. I appreciate it. I'll try to do 1 or 2 more lives later this week. That'll be it. Everybody enjoy their evening. I'm tired. I'm hungry. I'm about to go to sleep. It's past my bedtime. The Supreme Litigant is out. Peace, y'all.